The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Our next case is State versus Clegg, and we'll hear from the appellant.
Good morning, Your Honors, Honorable Chief Justice, Associate Justices of the Court. My name is Dylan Botham. I'm representing Christopher Clegg in this matter, and I would like to reserve 5 minutes of my time, please, for rebuttal. Thank you. The job of enforcing State versus Batson rests first and foremost with the trial judges. This is what our Supreme Court has told us. In the present case, the trial court had 2 opportunities to enforce Batson, and both times the trial court failed in its duty. In so doing, the trial court chose to look at the evidence in the light most favorable to the prosecutor, and even then, the trial court found that the prosecutor's proffered reasons for its strikes failed, or at least, for the strike of Miss Aubrey failed. The court chose to reject the strict application of the precedents of the United States Supreme Court, right there in the black letters of its order. And in so doing, the court chose to fail to consider many of the facts and circumstances that bear on the issue of racial discrimination, which arose in this case. As I'm going forward, I will explain how these reasons show that the court's ruling in this case was clearly erroneous. When you consider all of the facts and circumstances in this case, Mr. Clegg has carried his burden to show that the prosecutor's strikes of Ms. Gwendolyn Aubrey and Ms. Viola Jeffries were motivated in substantial part by discriminatory intent. Beginning with the numbers in this case, these facts are undisputed. The prosecutor struck black jurors at 6 times the rate of white jurors. The prosecutor struck all of the black women from the jury and 2/3 of the people of color. In contrast, the prosecutor struck only 11% of the white jurors, 2 of 19. These numbers don't arise in a vacuum. Statewide, as this court is well aware, research has shown that black jurors are twice as likely to be removed by white jurors. The probability of this disparity occurring in one study was calculated to be less than 1 in 10 million. Wake County also has a racial disparity, which is remarkable. In 2011, 2012, just a few years before the trial in this case, the prosecutor struck black jurors in Wake County 1.7 times the rate they struck white jurors. One of the ways the trial court's order is clearly erroneous in this case is that the trial court disregarded these statistics when it evaluated the significance of the prosecutor's strikes. The trial court order states there was no evidence of a policy of the prosecutor's office to discriminate against black jurors, but this is not the case. There was evidence before the trial court that this prosecutor's office has a sustained routine practice of removing black jurors more than they remove white jurors. Further, to the extent the trial court did consider this historical evidence, the trial court only considered it in the context of the prima facie stage of Batson. The trial court did not consider the strikes themselves in that context at the 3rd step of Batson. When ruling on the ultimate question, the trial court disregarded this historical evidence, both locally and statewide. Now I'm going to turn to the fact to the pretextual reasons the state gave for striking juror Gwendolyn Aubrey. Step 2 of Batson ought to be absurdly easy for any litigant to meet their burden. It's a simple burden of production. The litigant should be able to, if they have a legitimate race-neutral reason for striking the juror, it should be very simple. Yet when the prosecutor was asked why he struck Miss Aubrey, he couldn't provide a legitimate reason. At trial, he first claimed that he doubted her ability to be impartial, and he claimed that she could have been struck for cause. He justified this concern based on a response she gave to a question where she had initially replied, "I suppose." He said she was equivocal about her ability to be fair. But that was not the question the prosecutor had actually asked.
Well, it's Mr. Botham, perhaps.
Her ability to focus.
Mr. Botham.
Yes.
You may be getting to the question I had, but what was the question the prosecutor asked?
The prosecutor asked Miss Aubrey whether she would be able to focus on the trial itself and have it keep her attention, and she said, "I suppose." The prosecutor then subsequently asked her a second time.
The exact question?
And actually, let me step back. He actually asked her if she was confident that she could focus. And she said, I suppose. And then he restated the question to her and said, asked her again whether she thought she could focus, and she said yes. But I think what's significant about this and this particular interaction, and I was going to get there in a moment, but I'll address it now. The prosecutor singled out Miss Aubrey for this line of questioning after a white male juror, had actually volunteered that he was going to have trouble focusing. The prosecutor asked the entire panel, Miss Aubrey and Mr. Brian Williams, whether or not, among other jurors, whether or not there was anything going on in their lives that would be a distraction that would make it difficult for them to focus on the case. Mr. Williams immediately interjected and said, I've got work, a concern he had raised before. And he said, that's going to be, he replied to this question about focus by saying his work would be a distraction. The prosecutor's response to Mr. Williams' comment was to say, okay. That's it. That's all the prosecutor said to Mr. Williams. The prosecutor said, okay. And then turned to Miss Aubrey and started to ask her about her ability to focus. The prosecutor let Mr. Williams serve. There was a second white male juror who was even more notably similarly situated. Juror David Smith was actually called to replace Miss Aubrey after the prosecutor struck her from the panel. And Mr. Smith went in great detail to how his work would be a distraction. The court initially asked whether it would be a burden for him to serve. He said, well, it's only busy season. I'm a small business owner. I'm one of 3 employees. I've already had to shuffle things around to get here. And as the week goes on, it's going to get progressively more difficult. The court asked him whether that would be a distraction. He said, I suppose so. It's going to be difficult. And the court said, well, there are going to be more questions about that. The prosecutor was totally unfazed by this. The prosecutor, in fact, did not ask him about his ability to focus, but turned to him and said, can you logistically make this work? And he said, yes, I can make it work, but it's going to be difficult. And the prosecutor was satisfied with that and allowed Mr. Smith to sit on the jury. The Supreme Court has ruled that these comparative juror methods are one of the best ways for us to look at what a prosecutor's intent was. And I think that, when you look at this, the prosecutor's interest in Miss Aubrey's focus really is revealed as pretext, because these white jurors were substantially more equivocal and reserved about their ability to stay focused and on task, and the prosecutor was unconcerned there. I'll back up again a little bit because
I'm sorry, Mr. Buffing, I just would like to follow up on what your argument is with regard to the significance of the trial court's failure to consider the disparate questioning of white and black potential jurors. Because as I read your brief, I understood you be saying that there's actually numerous legal errors in how the trial court's most recent order, that it's a legal error to fail to consider the disparate questioning of white and black jurors, that it's a legal error, a second legal error, to not apply Foster v. Chapman's instruction that misrepresentations or misspeaking about what the potential juror actually said, and this is in reference to Ms. Aubrey that you've already talked about, the fact that he thought she was saying, I suppose so, to whether or not she could be fair and impartial, when in fact it was a question about, did she think that she could focus? That Foster v. Chapman says that shifting explanations are evidence of pretext. So isn't it a legal error for the trial court not to consider that as evidence of pretext?
I think that's correct, Your Honor. I do think it's a legal error. And I think what Your Honor is getting at is the question of what is the standard of review here, what this court should be looking at in the trial court's ruling. It has been consistently treated as a standard of review, clearly erroneous standard of review. It does make more analytical sense to look at these legal errors under a de novo standard. The question really is, did the trial court correctly understand how the law applies to these facts? And I think that it's worth considering that a de novo standard is a more sensible approach. But the fact remains that currently the case law hasn't applied a de novo standard in these types of cases. This court is free to do so, even if it's a more searching standard than what the United States Supreme Court has done. But under the clearly erroneous standard of review, I think that also is met in this case. Going back to the question here of why this the trial court's analysis here was clearly erroneous. First, the trial court made a ruling that the prosecutor misremembered the question. And the reason the prosecutor was confused was the prosecutor believed that Miss Aubrey had said that she was unable to be fair and impartial, and the prosecutor was concerned about that. But if you look carefully at what the prosecutor argued on remand, the prosecutor never made that claim. The prosecutor only made that statement at trial, and then subsequently, where the prosecutor said, she could have been removed for cause. But then on remand, the prosecutor returns and says, look, I was confused. I misspoke. And then the prosecutor goes on to argue fairly extensively that his real concern was about her ability to focus. He was concerned about her ability to focus, coupled with her body language. This is a standard concern for him. And he spent a great deal of time making that argument. And the court recognized that position was inconsistent with what he had said at trial. And what he had said at trial, of course, was that she could be removed for cause, that she couldn't be fair. He was worried about that. And it was the court that stepped in here and said, looking at the evidence the evidence in the light most favorable to you. So here we are, the court's taking a side, saying we're going to give you the most deferential view of the evidence.
And is
you
there
actually misremembered the question.
Is there a case? I'm sorry. I just want to follow up on what you just said. Is there a case that says in the Batson context, the trial court is supposed to take the evidence in the light most favorable to the state after a prima facie claim has already been established?
At the third stage, I am not aware of any case that says that the evidence should be viewed in the light most favorable of the proponent of the strike. The question is whether the intentional discrimination has been shown by preponderance of the evidence. The burden on the person to challenge the strike is to show a substantial likelihood that race was a motivating factor in this strike. And we go back here to the question, what exactly here is this evidentiary burden of proof, and what are the courts trying to do? What we're trying to do is reduce the risk. We're not talking about a certainty of racial discrimination. We're just saying, what is the risk that we're willing to accept? And where there's a substantial likelihood, the court is supposed to reject the strike and uphold the challenge. So no, there's no reason to believe that there's any deference due to the proponent of the strike in the view of the evidence. And so that is one of the ways in which this trial court's, what it reveals about what this trial court is doing, what this trial court did, is this trial court is seeking out ways to justify the strike. The trial court began with a presumption that this was a legitimate strike, and we just got to figure out how to justify it. And so the trial court says to the state, says to the prosecutor, actually, you didn't misspeak, you misremembered, because if you misspoke, that would be inconsistent with what you said at trial. You misremembered. Prosecutor's response to that is right. And then the prosecutor goes back and starts arguing again that he was concerned about Ms. Aubrey's ability to focus. So at no point really on remand did the prosecutor stand by his initial statement that, I was afraid she couldn't be fair. Maybe my concern was unfounded, but that's because I misremembered her answer. That would have revealed that standing by his answer might have been a stronger position, would have been a stronger position. But by shifting his explanation and now taking the position, actually, I was concerned about her focus. The prosecutor has revealed that he never really was concerned about her focus. He was never really concerned about her fairness. These are pretextual reasons.
Mr. Buffum, did
the trial court, I'm sorry.
Did the trial court inquire of Juror 5 as to her ability to focus?
So both of the Black women who were removed were Juror 5. As to Ms. Aubrey, the second person to occupy that seat, the trial court's initial question to the whole panel was whether there was anything in their lives that would be a substantial impediment to serving. And Ms. Aubrey's response to that, now I think it's worth keeping in mind that when Ms. Aubrey responds to this question, she's already seen at least 13 jurors answer that question. She's seen one juror say, you know, I'm worried about making arrangements to find a substitute teacher. And she saw the trial court say, you know, make your arrangements. She saw two other jurors say, I'm worried about finding childcare for my kids during this. And the trial court said, make arrangements. She saw yet another juror say, you know, I've got an elderly parent who's sick and I've got to take them to medical appointments. I'm really worried about this. And she saw the trial court say, you know, please see if you can make arrangements. So when the trial court asked her this, and she's also seen a number of jurors say, who she knows are employed, say, no, I don't have any burden. So when the trial court asked her, you know, do you have any substantial burden? She says, other than missing work, no. I think what she's telling the court is, you know, this is not a burden that rises to the level of what you're looking for. The trial court had said, you know, I'm looking for questions about medical emergencies, medical treatments, prepaid vacations. So she's dismissing her work as a logistical burden.
Well,
in contrast,
she indicated that other than work, there was nothing that would impact her focus. Is that right?
That's correct, Your Honor. She wasn't, I'm sorry, Your Honor. She wasn't responding to a question about focus when she said that. She was responding to a logistical question when she said that. Can you make arrangements? Is there a burden here?
Similar question was asked of juror 11. Is that correct?
So juror Brian Williams was asked the logistical question, and he provided more detail about why his work would be difficult to make arrangements for him to leave. He went into detail saying, you know, I'm supervising people and this is going to be difficult, but I can jump things around.
Did he say it was difficult, or did he say he had 11 people who could take over?
He said he was supervising 11 people, and that he could juggle things around.
So when Mr. Williams attempts to interject during questioning, is it possible that the prosecutor had the information he needed about Mr. Williams' ability to focus?
Well, Your Honor, Mr. Williams hadn't been asked about his ability to focus. And so when the prosecutor follows up on the court's question with a question about focus, Mr. Williams restates his concerns about work. He brings it up again a second time saying, yeah, I told you I have these logistical problems. Now I'm telling you it's going to be a distraction.
Well, and Mr. Williams did not state that he had to work night and day shifts. And he did not state that he had concerns about his ability to focus. Is that correct?
He did, Your Honor, in response to the prosecutor's question, he did state that he had concerns about his ability to focus. The prosecutor asked as a follow-up whether or not this would be a problem for focus. And Mr. Williams is the one who volunteered information. Ms. Davis offered, Ms. Aubrey did not raise her hand, did not speak up. And the prosecutor ignored Mr. Williams to turn to Ms. Aubrey and press her on the issue.
And again, is it possible that Mr. Williams' answer to the judge's question was sufficient information for the prosecutor to determine for himself that Mr. Williams could focus?
Mr. Williams' answer to the trial court's question did not indicate that he was able to focus. The trial court didn't ask about that. So I don't think that that's a reasonable inference to make from the transcript. I would also point the court to the second white male juror who was even more clear and more concerned about his ability to focus based on his work. This small business owner, David Smith, who said, you know, I got two employees. We've already had to shift things around today to make arrangements. If I'm forced to be here, I'm going to have to close my store. I'm going to have to put off my customers. And he offered this information both in response to the logistical question, but also in response to a question about focus. And when the prosecutor was asked to follow up on that, or given the opportunity to follow up on that, the prosecutor didn't ask him about his focus. The prosecutor then asked him about the logistics and was satisfied that logistically it could be done.
Does an attorney have an obligation? Does an attorney have an obligation to follow up on every interjection by a juror? Or is that a choice that an attorney can make?
Certainly an attorney can decide that what a juror has offered is not significant for their evaluation of that juror's ability to serve. But when the prosecutor says, My concern here was their ability to focus, and the jurors are raising their hand saying, I'm worried about my ability to focus. That reveals the prosecutor's reason, this focus reason, to be pretext. It reveals that the prosecutor wasn't concerned about Mr. Williams' ability to focus, even though Mr. Williams said he'd had a problem with it. He wasn't concerned about Mr. Smith's ability to focus, even though Mr. Smith said he was concerned about it. The prosecutor was only concerned about focus when it came to the African American woman on the panel, when it came to Miss Aubrey. And that is evidence right there of pretext. Now, if the prosecutor had asked questions about something entirely unrelated and which had never been proffered as a reason to strike a juror, and had asked disparate questions, but actually that wasn't his reason for making any strikes, that would be fine. That would not be a problem.
Counsel, while you're transitioning,
I'm sorry.
I'm sorry. I don't mean to interrupt your flow, but while you're transitioning, I just have a quick question about the impact of the Batson claim in this case. And am I right that your client has now served all the time that he was sentenced for in this case and has been released from parole earlier this year?
That's correct, Your Honor. As of a few weeks ago, when I last checked, Mr. Clegg is completely free from the supervision of the state of North Carolina. He is all of his rights have been restored, with the exception of those rights, those restrictions which continue by virtue of a felony conviction. So going back to
let me ask you this: is it a proper consideration when someone says, "I work day and night"? I assume meaning to meet the needs, the financial needs of my family. Is that a proper consideration in considering preemptory challenges?
Well, first, Your Honor, I don't know that that's exactly what she meant when she said she worked day and night. I'm not sure she was saying that she works a double shift or that she has two jobs. I think my reading of that was simply that she had a variable schedule. But regardless, that is not the reason that the prosecutor offered for removing Ms. Aubrey from the panel. He did not say that he removed her from the panel because he was worried about her ability to make ends meet, that this would be an undue burden on her. And in fact, if he had, there are similarly situated white jurors who made the same concern known, or made that concern known at a much more forcefully than Ms. Aubrey had, like Mr. Smith.
So my question was, is that a legitimate consideration if someone says that they work day and night and would miss work?
If a litigant wanted to remove a juror because they felt that the service would be too much of a burden by missing work, that would not be a racially discriminatory reason. And of course, a peremptory challenge is legitimate as long as it's not based on race. But that was not the reason the prosecutor offered. That was not what the prosecutor said his concern was. And so we're not concerned here today, nor was the trial court concerned with whether there was some reason that the prosecutor might have removed her based on her answers. And as we know, the Supreme Court has rejected the approach that if there's some reason supported by the record, that it is an excusable strike, that is a legitimate strike. The Supreme Court has said we need to evaluate the reasons the prosecutor gave and determine whether they're pretext. And of course, the prosecutor in this case, with regards to Ms. Aubrey, gave a reason that he was worried about her fairness. Then, when confronted with the fact that there was no support for that, changed his explanation, said, I'm worried about her focus, and really nailed down on that, burrowed in on it. The prosecutor coupled that and with his articulated concern about her demeanor. And I do want to turn to the demeanor discussion at this point. It's really significant to me that in this case, that when the prosecutor talked about the demeanor of the Black women, the prosecutor couldn't distinguish between them. Demeanor can be a legitimate reason for removing a juror, but it needs to be something that's supported by the record. And the prosecutor needs to be clear, needs to be reasonably specific, or I'm sorry, the proponent of the strike, it's not always a prosecutor, needs to be clear, reasonably specific, and needs to explain how it's related to the case to be tried. In this case, the prosecutor offered no clarity about the demeanor that he was concerned about. He was so unspecific that he said it applied equally to both of the Black women. They both looked shifty to him in exactly the same ways. He was bothered by, quote, their body language, unquote. He was bothered by, quote, their failure to look at me, unquote. He said, quote, both potential jurors in seat number 5, their body language to me, they would not look at me, unquote. He never once specified which of these 2 jurors did what. He didn't explain what he would infer from it. He never explained how it was related to this case. He relied on a generic excuse without any relation to this case, and he applied it indiscriminately to all of the Black women on the jury. And in fact, I would suggest that not only is this reason not clear, not specific, not related to the case to be tried, it's not even race neutral on its face. The prosecutor told the court he didn't like the way the Black women look. He said, I don't like the way these 2 women who are both Black women, they don't look good to me. In my reading, that's a statement that he removed them because of their race, because they as a class, as a category, didn't behave, didn't look the way he thought they should. But even if you accept it as race neutral, even if his failure to utter the words, you know, African American is enough to say it's race neutral. It doesn't have any weight here because it doesn't have any real justification or explanation of why either of these jurors were removed. And it reveals, frankly, that his inability to articulate anything about it was just a pretext. He just needed a reason to point to. And we know, of course, that prosecutors have been trained in this state. Now, we don't know that this prosecutor was, but we know that prosecutors in the state have been trained to point to demeanor when they're confronted on Batson.
Counsel, you're well within your rebuttal time.
Goodness, thank you, Your Honor. I will leave it there.
We'll hear from the appellee.
May it please the court. I'm Amy Irene. I'm with the Department of Justice, and I represent the state in this appeal. This court remanded this case to the trial court for reconsideration of the defendant's Batson challenge in light of the U.S. Supreme Court's decision in Foster v. Chapman. On remand, the case came back before Judge Ridgway, who was the trial judge. The trial court on remand did exactly what this court instructed it to do. It reconsidered the defendant's Batson challenge in light of Foster. After carefully doing so, the trial court determined that the defendant had not met his burden of proving purposeful discrimination. The defendant had not shown it was more likely than not the peremptory challenges were improperly motivated. And on appeal, a trial court's ruling on discriminatory intent must be sustained unless it is clearly erroneous. Here, the trial court's order on remand is not clearly erroneous, and it therefore must be sustained. The defendant has raised 2 arguments in this court that relate to the 3-step Batson test. Of course, the first step is the prima facie showing, which is not at issue here. The second step is when the burden of production shifts to the state to offer a race-neutral explanation for its peremptory challenge. And then at the third step, the trial court decides whether the defendant has met his burden of proving purposeful discrimination by the state. The defendant has made in his brief, and I believe here today, arguments that relate to steps 2 and step 3 of the Batson test. And so turning briefly first to the step 2 argument, this court's remand order instructed the Superior Court to reconsider this case in light of Foster. Foster explicitly said it was only addressing step 3, and the defense at the remand hearing here specifically acknowledged that only step 3 was at issue, not step 2. But in any event, to the extent defendant is trying to contest step 2 now, his argument about that would fail because it conflicts with controlling U.S. Supreme Court precedent. The U.S. Supreme Court made it clear in Perkett versus Elam and again in Johnson versus California that the issue at step 2 is simply the facial validity of the explanation for a peremptory challenge. It is not until step 3 that the trial court considers the plausibility and persuasiveness of the explanation.
Counsel, on that question, is the issue of whether reason given is pretextual, isn't that a challenge to the facial validity of reason given by a proponent of the strike?
No, Your Honor, the question of whether the explanation is pretextual is something the trial court would decide at step 3 of the inquiry. At step 2, all that is at issue is the facial validity of the explanation given. And the U.S. Supreme Court clarified in Perkett some of the language from the Batson opinion about in Batson, the court had said the reason given is supposed to be legitimate, clear, and reasonably specific and related to the case to be tried. And that's some language defendant, I believe, has used here today. The U.S. Supreme Court clarified in Perkett that what it meant by that language in Batson was that the prosecutor could not just deny he was acting without a discriminatory motive or just say he was acting in good faith. And it clarified that what it meant by a legitimate reason is not a reason that makes sense, but a reason that does not deny equal protection. So a reason given at the second step that on its face does not violate equal protection satisfies step 2. And then at step 3, the trial court makes the determination of whether, given all the facts and circumstances in the case, that explanation is actually a pretext and is not the real reason.
So in your view, does it matter whether the reason given in step 2 is supported by the record?
Your Honor, as long as it is facially valid and does not violate equal protection, no, it doesn't. Now, certainly, is that something the trial court would consider at step 3? Yes. If the prosecutor gives a reason that's unsupported by the record, that's considered at step 3 when the trial court is considering the persuasiveness and plausibility of the explanation. But at step 2, the issue is the facial validity of the reason that was given. All of the reasons given here by the prosecutor at step 2 were facially valid. His reasons were that Ms. Jeffries had been employed at Dorothea Dix Hospital, that Ms. Aubrey had answered, I suppose, when asked if she could be fair and impartial, and the body language and lack of eye contact of Ms. Jeffries and Ms. Aubrey. These were facially valid race-neutral reasons at step 2 under Perkett. And the Perkett case itself, the reasons the prosecutor gave were that the prospective juror had long, unkempt hair, a mustache, and a goatee. The prosecutor didn't like the way the juror looked and thought the mustache and goatee looked suspicious. The U.S. Supreme Court said those are facially valid reasons at step 2. And so the inquiry proceeds to step 3, where the trial court would evaluate whether those are actually persuasive and plausible reasons, whether they're pretextual. And so here, I'm sorry.
So just to make sure I understand, the state's position is, as long as the proponent of the strike gives some reason, so they can't just say, I have no reason, they have to give some reason. And as long as the reason is anything other than, I struck that juror because, in this case, because of their race, then we proceed to step 3.
Your Honor, yes, with a caveat in that your question, I think, also asked about as long as the prosecutor gives some reason. I believe it was footnote 6 in Johnson v. California that talks about, in the unlikely event that the prosecutor declines to give any reason at all, the prosecutor's refusal to give a reason would be considered by the trial court at step 3. So,
well, but doesn't this court have I thought in North Carolina courts, we said that we did have a case where there was a failure to provide any explanation whatsoever for a strike. And we said that fails step 2.
That may have been I'm not recalling, it may have been a Court of Appeals decision that's in the defendant's brief, but Johnson versus California footnote 6 addresses that scenario and says, of course, the trial court would consider it step 3 if the prosecutor just outright refuses to give a reason. But here what we have is that's not what happened. The prosecutor gave reasons, and the reasons he gave were facially valid reasons that do not violate equal protection on their face. And so the inquiry properly went to step 3. the defense did not contest at all at the remand hearing here that step 3 is what is at issue. And this court's remand order remanding the case for reconsideration in light of Foster, which explicitly says it's a step 3 case, certainly supports that position. And so turning to the step 3 argument here, at step 3, the prosecutor's race-neutral explanation is considered by the trial court in light of all the relevant facts and circumstances and the arguments of the parties. I have not heard defendant today really challenge the prosecutor's explanation that he struck Ms. Jeffries because of her employment at Dorothea Dix. That reason was certainly supported by the record, and the reasons for that are set forth in detail in the state's brief. But that reason was supported by the record, and the trial court on remand in its order also said that.
And let me ask you about that, because I understood the defendant's argument on that point to be that the issue of the defendant's capacity had already been resolved. It was not, and so his argument is actually not supported by the record, because there wasn't going to be any issue in this trial raised about whether or not he had mental illness or capacity in any way, that had already been resolved.
Your Honor, I believe that is what he argued in his brief. I have not heard him argue that today, but to address that point, yes, it's correct that the jury would not be deciding a defendant's competency, and there was not an insanity or diminished capacity defense for the jury to decide. But what the trial court said was that at trial, what he said was that he peremptorily challenged Ms. Jeffries because she had been a nurse's aide at Dorothea Dix. The prosecutor said that with some of the underlying issues that have been brought out so far, I found that maybe she would not be able to fairly assess the evidence in this case. He reiterated that reason at the remand hearing, explaining that it's clear from the record and the pretrial motions and arguments that were made that mental health was an underlying issue and concern for the defense primarily. He said he was concerned she would be sympathetic to the defendant, even though there was overwhelming evidence of his guilt. She was the only prospective juror who said she had worked in the mental health field. And the fact that he was concerned about her employment was evidenced by the fact that he had asked her some follow-up questions about the nature of her employment at Dix. This court has I'm sorry, Your Honor.
Well, I'm just looking at the trial court's actual order on that point. And in paragraph 3, he addresses that and says the state's stated reason for striking Ms. Jeffries due to her work history in the mental health field is rationally related to the defendant's potential competency issues. But there weren't competency issues at this stage for the jury to decide.
Your Honor, I think the potential competency issues encompasses the fact that there were sufficient concerns about defendant's competency such that a competency evaluation had been done. He was found competent, but the potential competency issues encompasses the fact that the prosecutor could, on this record, would certainly have good reason to be concerned about the fact that this defendant might display behavior and demeanor in the courtroom outside the norm that could cause a juror who had worked at a inpatient care at a mental health hospital to sympathize with him. And that's replete throughout the record. The record shows there had been a competency evaluation done. It also, the record shows that even before the Batson objection was made, this defendant had filed pro se motions that the trial court described as evidencing beliefs consistent with people who claim to be sovereign citizens or have allegiance to the Moorish nation. And then subsequent events underscore that concerns about, although this defendant had been found legally competent to proceed trial, that there could be concerns in connection with the types of issues that had caused a competency evaluation to be done in the first place. Specifically, this defendant engaged in exchanges with the trial judge himself, even though he was represented by a lawyer. He said he might want to fire his lawyer and proceed pro se, which of course would be his right, but that would mean the defendant himself would be talking and interacting with witnesses in front of the jury. Prospective juror David Williams said he had observed a reaction from the defendant the prior day that he was not impressed with during jury selection. And then in closing argument, defense counsel made what appeared to be several appeals to the jury's sympathy and references to the defendant's mental status by saying, you've been able to watch him for 2 days. I would venture to say he's a somewhat troubled young man. This was not a logical act. It's not a rational crime. This case shows how confusing life can be for some people. So all of this in the record does support the employment reason that the prosecutor gave for peremptorily challenging Ms. Jeffries, and they do all relate to what the trial court in its order used the phrasing potential competency issues to describe. The court said the reason is supported by the record and is an appropriate justification for the strike. And so that was Ms. Jeffries. The defendant, of course, has argued quite a bit today about Ms. Aubrey. The prosecutor at trial said that one of his reasons for peremptorily challenging her was that she said, I suppose, when she was asked if she could be fair and impartial. The prosecutor said he was not confident. She was confident she could be fair and impartial, and that could be a potential reason to challenge her for cause. Ms. Aubrey had actually given that answer, I suppose, in response to the question of whether she could focus, not whether she could be fair and impartial. So the prosecutor was mistaken at trial when he said that she answered, I suppose, when asked if she could be fair and impartial. But it is noteworthy that Ms. Aubrey did, in fact, give the answer, I suppose, in response to a question during voir dire. So this is not like the situation in the Foster case, where the U.S. Supreme Court said the prosecution's explanation had no grounding in fact. And the trial court correctly explained that in its remand order at paragraphs 25 and 27. The U.S. Supreme Court in the Flowers case said that if there's a pattern of factually inaccurate statements or a series of factually inaccurate statements, that could be suggestive of discriminatory intent or an intent to keep Black prospective jurors off the jury. That is consistent with Foster, where the U.S. Supreme Court said it was not faced with just a single isolated misrepresentation. But in this case,
can I just be clear then? Are you disputing what the trial court finds in paragraph 15 of its order, where it says, as such, both race-neutral justifications, that speaking now about Ms. Aubrey, as such, both race-neutral justifications offered by the prosecutor fail. And then he goes on to say, one, because the prosecutor misremembered the question to which Ms. Aubrey responded, I suppose, and the other because the trial court failed to make sufficient findings of fact to establish a record of Ms. Aubrey's body language. So are you saying that's not correct?
No, Your Honor. What I'm saying is the trial court did find in the remand order that the prosecutor had misremembered. He made a mistake. He admitted at the remand hearing he made a mistake. He said he got confused, and he confused Ms. Aubrey's questions and answers. And so the trial court's correct that that record fails and that it's not supported by the record because the prosecutor misremembered the question to which she responded, I suppose. But the trial court did also explain in its remand order at paragraph 25, where it's talking about Foster, that the prosecutor's explanations in Foster had no grounding in fact. And then again at paragraph 27, the trial court talked about this case is markedly distinguishable from the controlling authority, which is Miller L. and Foster that the court was talking about in the preceding two paragraphs. It says it's markedly distinguishable because there was not a mischaracterization of the record with no grounding in fact. Here, this juror did give the answer, I suppose. The prosecutor just got confused about which question she had given that answer in response to. And so that is a difference between this case and Foster. And the U.S. Supreme Court in Flowers recognized that a Batson hearing can be hurried, prosecutors can make mistakes. The court said that's entirely understandable, and mistaken explanations should not be confused with racial discrimination. When Batson objections are raised, the prosecutors don't have the benefit of a verbatim transcript to parse back through like we do on appeal. Prosecutor candidly admitted at the remand hearing here that he had made a mistake. He said he made the mistake because he was flustered, and he said he confused Ms. Aubrey's questions and answers. And that's
Can I ask you then how we are to understand what legal standard the trial court applied in paragraph 23 of its order. It says that, even on what it characterized as a relaxed, more likely than not standard, this court concludes that essential evidence of purposeful discrimination is lacking. Is the trial court there seeking direct evidence of purposeful discrimination?
Your Honor, if I'm understanding your question, I think what the trial court is saying there is that on this record, when you consider all the facts and circumstances, it can't conclude that purposeful discrimination occurred, or it cannot conclude that the defendant has met his burden of showing it's more likely than not, because this record shows the employment reason for Ms. Jeffries was supported. The prosecutor made an honest mistake about Ms. Aubrey, but making a mistake is not the same thing as purposefully discriminating. The trial court, contrary to what I believe defendant has argued here today, did consider the peremptory challenges in this case, the breakdown of the numbers. The state used equal numbers of peremptory challenges to remove 2 Black prospective jurors, 2 white prospective jurors. The trial court also talked about the total breakdown of the veneer in terms of racial composition. That's all in the trial court's order at paragraph 17. Considering everything in the record here, the evidence of purposeful discrimination was lacking, and it's defendant's burden to prove that. At step 3, the burden of persuasion is always with the defendant and never shifts from the defendant. In the Batson test, at step 3, it is his burden to prove purposeful discrimination. The prosecutor did not shift explanations for the peremptory challenge of Ms. Aubrey at the remand hearing as defendant has suggested. He said he got confused, and he confused her questions and answers. The trial court did not supply or substitute new reasons for the peremptory challenge or allow the prosecutor to do that. That's clear from the trial court's remand order and also from the remand hearing. At paragraphs 8 through 11 of the remand order, the trial court makes it very clear that it understood that under Miller L, it was not allowed to substitute reasons for the peremptory challenge that the prosecutor did not give. The trial court also made that clear in the remand hearing transcript at pages 45 and 49. The trial court credited the prosecutor's explanation of his mistake in its order at paragraphs 7 and 15 and said it's evident from the record that both the trial court's and the prosecutor's memory of the answers given by Ms. Aubrey were conflated, and that the prosecutor misremembered the question to which Ms. Aubrey responded, I suppose. This type of credibility determination is entrusted to the trial court and should be given great deference on appeal. Defendant, I believe, has argued about the fact that he claims the trial court viewed matters in the light most favorable to the state. And so I want to briefly address that. The trial court did use that phrase at the remand hearing, but the remand order shows that that is not the legal standard that the trial court applied here. The trial court instead explained in its remand order that, as the defendant points out, the applicable standard is given all relevant circumstances, whether it was more likely than not that the challenge was improperly motivated, and that even on this relaxed, more likely than not standard, this court concludes that essential evidence of purposeful discrimination, which is the defendant's burden to prove, is lacking. That's paragraphs 23 and 29. And I believe paragraph 23 is the paragraph you were just referring to, Justice Earls. But the trial court clearly knew what the appropriate legal standard was and applied it here. It did not enter a ruling at the remand hearing. It took the matter under advisement and entered its ruling later. And in that ruling, it did apply the correct standard. Regarding the body language and eye contact reasons given as to Ms. Jeffries and Ms. Aubrey, I do want to clarify that I believe my colleague may have said something to the effect of that they looked shifty. That is not what the prosecutor said at all here. What the prosecutor said was he gave his reasons at trial, their body language, and failure to look at him when the prosecutor was trying to communicate with them. This court has said that body language and lack of eye contact can be appropriate reasons. non-discriminatory reasons for a peremptory challenge. But in this case, what the trial court ruled in its order was that because it had not made specific findings of fact at trial about the body language and eye contact reasons, it appeared that those reasons could not be viewed as sufficient for appellate purposes. So the trial court in this case did not rule that these reasons were pretextual, that they were false, that they were being used to cover up any kind of racial discrimination at all. What it said instead was that it appeared because it had not made, the trial court had not made findings at trial, it appeared those reasons could not be viewed as sufficient on appeal. Regarding the argument about disparate questioning, I want to clarify that I believe the defendant is arguing the prosecutor engaged in disparate questioning with respect to Ms. Aubrey as compared to white prospective juror David Williams, not Brian Williams. There were two prospective jurors with the last name Williams. And so it's David Williams, I believe he's referring to. The U.S. Supreme Court has not said that all differences in questioning are indicative of discriminatory purpose. What it has said is that dramatically disparate questioning considered with all of the other facts and circumstances can be evidence of discriminatory purpose. And in this case, there was not disparate questioning, certainly not dramatically disparate questioning. The sequence of questioning the defendant is pointing to is at pages 100 to 101 of the trial transcript, quoted in the state's brief at pages 49 to 50. The trial court did consider this sequence of questioning in its order at paragraphs 19 and 20 of the remand order. And so I believe there was some mention of, did the trial court consider that? And if I'm remembering that correctly, that came up, yes, the trial court did. Paragraphs 19 and 20, the trial court considered the comparison of that questioning. In that question,
Counsel, I'm sorry. What role does a trial court's preliminary questions to a juror or the jury veneer or the panel, what role do those questions play in our analysis?
Your Honor, I think the role they play is that certainly the prosecutor at that point would have information that was elicited during the trial court's questioning. And so it would be in combination with already having the information the trial court has elicited that the prosecutor might ask follow-up questions. And in this case, the prosecutor did follow up with all prospective jurors who had indicated during the trial court's initial questioning that they might have something that would make it difficult or impossible for them to serve on the jury. He consistently asked all other prospective jurors, either individually or as a group, whether they would be able to focus and or make arrangements if they had said during Judge Ridgway's initial questioning that they had something that might make it difficult or impossible for them to serve on the jury. And that is laid out in the state's brief, in the statement of the facts. As to David Williams compared to Miss Aubrey, specifically that sequence of follow-up questioning, the prosecutor has said, again, I don't need to know specifics, but is there a possibility that your mind could drift somewhere else when we need you to be focusing on the proceedings here? His answer was, I have 11 employees out in the field, so, and I think defendant may have misquoted that today inadvertently, but that was what his answer was. I have 11 employees out in the field, so. And then the prosecutor's response to that was, okay, Miss Aubrey, do you feel confident you can focus on what's going on here? She said, I suppose. He said, I want you to be confident about it. You just don't want to be a juror, or do you feel like if you were here, you could focus and do what we need you to do? She said, I think so. And then he moved on to talking, the prosecutor moved on to talking about CSI type issues. So David Williams' answer, the most reasonable interpretation of it is that focus was not a concern for him. He had 11 employees in the field. There's no indication in the transcript that the prosecutor interrupted him or cut him off. There's no indication he continued trying to speak at that time or that the prosecutor was speaking over him. He had earlier told the trial court that he could juggle things around at work, which is consistent with the idea that he was not in fact, concerned about work. And then, although this was during defense questioning later, he did tell defense counsel that he had people in his office he could depend on, and he did not see an emergency coming so far. So this is not disparate questioning as the defendant contends. I think defendant today has made some argument about prospective juror David Smith. Defendant did not make that argument in his brief. He's making that for the first time in oral argument today. To the extent he's trying to make an argument that David Smith was somehow comparable to Miss Aubrey about ability to focus, the prosecutor's stated reason at trial for peremptorily challenging Miss Aubrey was her ability to be fair and impartial, not her ability to focus. And so comparing jurors regarding their ability to focus is really not applicable. That's not the reason the prosecutor gave. And Miller L teaches that you cannot substitute different reasons. But in any event, the prosecutor did follow up with Mr. Smith, asked Mr. Smith about his business and how Mr. Smith had said it would get more difficult throughout the week and whether he felt he could make arrangements and make it work. Mr. Smith said he would shut the store down, put a sign on the door. It said, I'm supposed to be in the store, so they're shuffling customers around and installation schedules to keep somebody in the store. The store would get locked up if we run out of road to rearrange the schedule. And then later, this was again during defense questioning, but later he did say he can adjust. So the prosecutor did follow up with Mr. Smith. He was giving much more detailed explanations than the explanations Ms. Aubrey gave. Her answers were very short and equivocal, unlike other jurors who gave more detailed and or unequivocal answers. Regarding the historical data argument, the trial court was not required to consider historical data here. The defendant made no argument about that at trial. He brought that up for the first time in the remand hearing, but nonetheless, the trial court did consider it. It is in the trial court's order, and that shows the trial court did consider and weigh it, specifically at paragraphs 18 and 22 of the trial court's order. There is no indication in the order that the trial court was considering this only at step one, as defendant seems to have claimed. The trial court was considering it in connection with step 3. The trial court correctly found that, unlike in Miller L., there was no systemic policy of racial discrimination in jury selection by the prosecutor's office here. I see my time is up, and so I respectfully ask that this court affirm the order of the Superior Court.
Thank you, counsel. Rebuttal.
The trial court's order, I'm sorry, am I muted? No, it's not corrected. I think it's very telling that the trial court's order begins by considering the prosecutor's justification for Ms. Jeffries and says this is a legitimate race-neutral reason, and then doesn't consider any of the other facts or circumstances to consider whether or not it might have been pretext, whether or not it was the actual reason the prosecutor used. The court just begins with the assumption, if the prosecutor can say something legit, if the prosecutor can articulate a reason, that's the end of the inquiry. The court's assumption is these are fine. There's no problem here. And it's only going to proceed to evaluate all of the evidence, all of the facts and circumstances of the case where the reason articulated by the prosecutor doesn't hold up, and so the court goes on subsequently to do that in the context of Ms. Aubrey. But even there, the court's order is clearly erroneous in a number of ways. The totality of the circumstances reveal that the prosecutor's stated reason for striking Ms. Aubrey failed. When corrected, the prosecutor doubled down on a new justification. The state's clarified now that the prosecutor's actual reason was that the prosecutor thought she couldn't be fair and impartial. She was equivocal about that. But that doesn't hold up because the prosecutor then spent most of the remand arguing about it, that he was concerned she couldn't focus. The prosecutor didn't once restate a concern about her ability to be fair. It was only the trial court that suggested, you misremembered the question, and that's why you made this mistake. The prosecutor came into court and took the position, actually, I misspoke. I was very worried about her focus. And this fact, this circumstance wasn't considered by the trial court, this shifting explanation. The trial court didn't consider the facts and circumstances that when the prosecutor discussed demeanor, he couldn't distinguish the two Black women. He couldn't describe the demeanor. The trial court also did not consider the fact that all of this arises in the context of a disproportionate rate of strike jurors and in an office with a recent history of racial discrimination and jury selection. I don't really have enough time to draw the court to spend a lot of time on this, but in Flowers, the Supreme Court, after considering the strike of juror Carolyn Wright, focuses specifically on the fact that the trial court's error, the clear error the trial court made, was that the facts of the trial court's mistakes, the facts of the trial court's disproportionate questioning were not considered by the trial court. I'm sorry, the prosecutors were not considered by the trial court in the full context of all of the facts. That's what we have here in this case. Mr. Clegg would ask this court to reverse the trial court's order, vacate the judgment in this case, and remand for a new trial. Thank you.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess until the next calling of the calendar. God save the state and this honorable court.